rights have to be interpreted in a broad and liberal manner, ensuring that our people enjoy their rights, our young democracy not only functions but grows, and the will and dominant aspiration of the people prevail. End of quotes. The guiding principle in determining whether the sections of an act of parliament are unconstitutional were succinctly laid out in the case of Institute for Social Accountability and another versus the National Assembly, where a three-bench of this court held as follows. First, that this court is enjoined under Article 259 of the Constitution to interpret the Constitution in a matter that promotes its purpose, values, principles, and advances rule of law, human rights, and fundamental freedoms in the Bill of Rights, and that contributes to good governance. In exercising its judicial authority, this court is obliged under Article 159 of the Constitution to protect, promote the purpose and principles of the Constitution. Additionally, we also looked at the petition of number 150 of 2016, which was consolidated with petition number 234 of 2016, Attorney General, E.G. and others versus Attorney General, where the three-bench judge held that the technique of paying attention to context in statutory construction is now required by the Constitution. As pointed out earlier, the Constitution introduced a mandatory requirement to construe every piece of legislation in a manner that promotes the spirit, purport, and objects of the Bill of Rights. The purpose of statute plays an important role in establishing a context that clarifies the scope and intended effect of a law. The often quoted dissented judgment of Schreiner J.A. eloquently attributes the importance of context in statutory interpretation he went on to say that certainly no less important than oft-repeated statement that the words and expressions used in a statute must be interpreted in according to their ordinary meaning in the statement, and that they must be interpreted in light of their context. But it may be useful to stress 2 points in relation to the application of this principle. That first is the context, as here used, is not limited to the language of the rest of the statute regarding as throwing light of a dictionary kind or of the part to be interpreted. Often of more importance is the matter of the statute, its apparent scope and purpose, and within limits its background. We further cited the case in SBM and another versus the Attorney General. Is a Supreme Court decision that states that it's unassailable that the approach to interpreting fundamental rights and freedoms in the Bill of Rights by this court has to take the model of looking at the Constitution as a whole, which is purposive and generous, giving effect to the Constitution of values, including substantive equality. In reaction to inequality and discrimination advanced by the petitioner in Prince Law versus this is a South African decision, where the court said it is convenient for descriptive purposes to refer to the differentiation presently under discussion as mere differentiation. I'll not quote the end of that ruling, but I'll go to the next broad issue. Under the broad issue of constitutionality, we identified the following points for determination. 1, whether there was adequate public participation. 2, whether the Affordable Housing Act violates Article 27 and 40 of the Constitution. 3, whether the Act infringes on Article 43 of the Constitution. 4, whether or not the Act amounts to a clawback on devolution. 5, whether the use of public land for development of affordable houses infringes on the functions of the National Land Commission. And 6, whether the Act is unconstitutional for failure by the CRA to consider the bill as per Article 205(1). On whether public participation was undertaken, the petitioners argued that the enactment of the Act was not done in conformity with the various tenets of the Constitution, one of them being public participation. While they concede that some measure of public participation was conducted, it was their submission that it was not sufficient. It was therefore their case that at best, what was done was a cosmetic exercise and a waste of public resources. The petitioners argued that whatever was done by way of public participation went contrary to Articles 10, 118, and 201 of the Constitution. In particular, the petitioners argued that the invitation notice to members of the public to present memoranda on the bill by the National Assembly within 7 days was too short, and thus the purpose of public participation cannot be said to have been achieved. Similarly, they contend that the deliberations of the Senate at the second and third reading stages was also constrained with the result that limited public participation to 7 days only, such that no public hearings could be conducted in any of the 47 counties. The petitioners also took issue with the fact that public participation was only conducted in 19 counties. They pointed out that 28 counties were excluded from the exercise in blatant violation of Article 10(1), 2A, and 27 of the Constitution. That the petitioners went further to state that the discrimination of the 28 counties and the refusal by the committee mandated with the conducting public participation or collecting views of the persons from the 28 counties was in blatant disregard of Article 47 of the Constitution of Kenya 2010, as read with Sections 4 and 5 of the Fair Administrative Act 2015, that require administrative action to be expeditious, efficient, reasonable, and procedurally fair. In addition, the petitioners submitted that although public participation was conducted in 19 counties, it was non-quantitative, non-qualitative, and therefore rendered meaningless. It was argued that public participation was conducted only in 19 counties while the National Assembly executes its mandate in 290 constituencies. The petitioners further argued that lack of proper public participation is evident from the reports of the National Assembly and the Senate. It was their case that the National Assembly and the Senate did not provide adequate opportunities for people's involvement in the legislative process of the Affordable Housing Act. In the same vein, the petitioners also submitted that Kenyans had legitimate expectation that the Constitution would be followed in conducting public participation. In conclusion, the petitioners urged this court to find that the Affordable Housing Act did not meet the constitutional parameters for public participation under Articles 10, 118, and 201 of the Constitution. In their response to this question on public participation, the respondents did not dispute that public participation is a requirement of the Constitution. To illustrate, the National Assembly indicated that it conducted civic education in languages comprehensive to the diverse communities in various locations before public participation sessions were conducted by providing fact sheets that gave information to the Affordable Housing Bill. In addition, advertisements in the local daily newspapers were done inviting the public to submit views on the bill by the deadline of 28 December 2023. Key stakeholders were invited to participate to make oral presentations before the committee in sittings that were held in Parliament buildings on 29 and 30th January 2024, 6th and 7th February 2024. The respondents admitted that public hearings by key stakeholders were held on diverse dates across 19 counties that included Narok, Kisii, Homa Bay, Vihiga, Uasin Gishu, Turkana, Baringo, Nyandarua, Nakuru, Machakos, Kirinyaga, Embu, Kiambu, Wajir, Tana River, Lamu, Kilifi, Mombasa, and Nairobi County. Additional meetings were held on various dates with the State Department of Housing, the National Treasury, and the State Law Office, among other government agencies, that allowed various agencies to make presentations to the joint committee. It is the National Assembly's case that it received and reviewed written memoranda submitted by the public and invited stakeholders. It is further the National Assembly's case that the majority of the stakeholders were overwhelmingly supported the bill, noting that promotion of investments in affordable housing has a multiplier effect on the economy through creation of employment, improved supply chains for the construction materials, and consequently will improve the general public. According to the National Assembly, the assessment of the Parliament's compliance with its obligation to facilitate public participation in the legislative process is guided by the principle of reasonableness, and there is sufficient evidence to demonstrate that the Act was procedurally and legally subjected to public participation per the Constitution and the standing orders of the House. As a result, the National Assembly urged this court to find that the Affordable Housing Act was compliant with the provisions of Article 10 and 118 of the Constitution. The National Assembly and the Attorney General alleged that the question of public participation had already been determined by a court of concurrent jurisdiction in the case of Appeal versus Attorney General and two others, that is the Kisumu petition, on February 29, 2024, where the court found that public participation in respect of the Affordable Housing Bill was compliant with the provisions of the Constitution. The Senate also asserted that the public participation in the Act was conducted per the law and its standing orders, and there was no requirement for public participation in the 47 counties as alleged. It denied that senators were gagged from fully and freely debating the bill and argued that there was no proof provided to this court by the petitioners to discharge that duty. On their part, the KRA indicated that the rate of 1.5 was picked, which was picked from the Finance Act 2023, was on reasonable grounds that it had undergone proper public participation, channels, stakeholder engagement, and the rationalization process, which proposed a reduction of the rate from the initially proposed rate of 3% to 1.5%. It was their case that the High Court judges did not counter the constitutionality and validity of the rate in the petitions challenging the Finance Act. The respondents' assertion that public participation was conducted within the principles of the Constitution was supported by the 10th respondent. I think this is the 10th interested party, COFEC. It was the COFEC's argument that the public participation was conducted within the confines of the Constitution, and that the opinions of Kenyans with regard to the provision of the collection of the levy of affordable housing by the state were considered before the impugned law was enacted. Having considered the foregoing arguments, it's important that this court first dispenses with the issue on public participation being res judicata in reference to the case of appeal. The respondents have stated that the issue of public participation at the National Assembly ought not to arise in this case, as the court already determined that it was compliant with the provisions of the Constitution. Conventionally, the doctrine of res judicata is designed to bring finality to litigation and to provide parties with closure and relief from the burden of being troubled or pursued in connection with issues and lawsuits that have already been resolved by a court of competent jurisdiction. And this is the holding in the Supreme Court in the case of Kenya Commercial Bank by Muiri and Muiri Coffee Estate Limited. I will not rehash what the Supreme Court said. The Supreme Court also reaffirmed on the side case and cited the case of John Florence Maritime Services and another was the Cabinet Secretary of Transport and Infrastructure, where it goes on to explain the principle of res judicata. The Supreme Court held that a court has discretionary powers to interrogate the matter before it and determine whether it may occasion substantial injustice to the parties, and in the alternative, it must be convinced that there are special circumstances that allow it to make exceptions to the doctrine of res jurisdiction. This court has perused the appeal case and noted that the petition before the said court was pegged on the impugned notice dated 9th December 2023, issued by the National Assembly in the local dailies, requiring public participation by way of submissions of memoranda for the Affordable Housing Bill number 775 of 2023. The said court noted that the petition only challenged, this court noted that the petition only challenged this mode of public participation on the ground that marginalized communities or persons living in the slums of Korogosho, Mathare and Kibera were not able to submit memoranda in the manner prescribed. The court has also looked at the issues raised on public participation in the 6 petitions, herein vis-a-vis the issues raised on public participation in the appeal case. It is our considered view that the issues raised in the instant petitions raise a broader question as to whether public participation was conducted at the National Assembly and the Senate within the tenets of Article 10, 118 and 201 of the Constitution, while in the appeal case the issue was specific to the mode used to conduct public participation. In any event, the court found that the issue was not ripe for determination, as the National Assembly did not only require submission of memoranda but also held public hearings as a mode of public petition. And we've cited the decision at paragraph 47 and 48 and 73 of the appeal court. We find the circumstances that the issue of public participation is not res judicata, and now proceed to consider the issue substantively. It is undeniable that public participation is essential to the legislative and policy functions of government, both at the national and county levels. Public participation is integral to the legislative enactment process. Under Article 10(2)(a) of the Constitution, public participation is one of the key national values and principles of governance. Article 118 of the Constitution provides as follows: Parliament shall A, conduct its business in an open manner, and its sittings and those of the committee shall be in public. Facilitate public participation and involvement in the legislative and other business of the Parliament and its committees. Failure to ensure public participation is fatal. Any action requiring it that proceeds without such involvement is invalid, as it violates an explicit constitutional mandate. This was the holding in the case for Doctors for Life versus the Speaker of the National Assembly and others. I think this is a South African decision that is widely cited. We are certain that public involvement was crucial prior to the enactment of the Affordable Housing Act. Public participation must be authentic, not just symbolic, and should not be treated as a mere formality to comply with constitutional obligations. It is important, therefore, that this court answers what defines proper and reasonable public participation as envisioned in the Constitution. We cite the decision in the South African case of Minister for Health and another versus the New Clicks South Africa, where the South African court held that the principles of fairness are not to be applied by rote identically in every situation. It cannot be expected of the lawmaker that a personal hearing will be given to every individual who claims to be affected by the regulations that are being made. What is necessary is that the nature of the concerns of different sectors of the public should be communicated to the lawmaker and taken into account in formulating regulations. End of quote. Public participation does not necessarily mean that everyone must express their opinions. Instead, there should be tangible evidence of a purposeful initiative to incorporate a variety of perspectives in the participation program. This was as held in the case of Muiko Basin versus
Dove is different. With 1/4 moisturizing cream, it deeply nourishes for radiant skin all over. Try Dove.
Our guest for the next 1 hour is an advocate of the High Court of Kenya and Tanganyika, Professor Patrick Loch Otieno Lumumba. Hello, good morning.
Good morning.
How are you?
I'm well.
Good to have you back here.
Thank you very much.
I said we have to find out why advocate of the High Court of Tanganyika. Why do you have to include it there? I thought it was like automatic when you're an advocate of a High Court of Kenya, then you can be admitted to the bars of Tanzania and Uganda. And
no, you've got to be specifically admitted to the bar of Tanganyika.
Mm-hmm.
Remember, Zanzibar has a different bar. So this is not automatic.
It's not automatic?
No, not at all.
So a Kenyan advocate cannot just go and practice?
Does not have right of audience in the courts of Tanganyika.
Okay.
Unless they are admitted as such.
Did you have to sit a bar exam in Tanganyika?
What happened at that time is that you had to have an interview with the Chief Justice. Mm-hmm. And the Chief Justice spent how many hours with me? 6 hours asking me questions about the laws of Tanzania and Tanganyika. And when he was satisfied that I knew the law, he recommended that I be admitted. Tanzania did not have bar examinations then. They have now introduced it like we do in Kenya.
That's interesting. So you actually did study the laws of Tanganyika and Tanzania.
Yeah. You've got to be satisfied that I'm fit to practice in Tanganyika.
Sasa interview ilikuwa kwa Kiswahili ama
kwa Kiingereza na Kiswahili?
So swali la kwanza kaka Mpendo.
Kwenye haya maudhui. Sheria kwa kipengee. Karibu sana.
Asante sana.
City will welcome you with today's proverb. And this week the proverbs are from the Gambia.
Yes, the Republic of the Gambia, not just Gambia. This proverb is actually interesting. If you stir up water in the pond, you will bring up the pond.
If you stir up water in the pond, you will bring up the pond. Prof, what's your interpretation?
You make the pond come alive. That is how I understand it. Because if it is not stirred, then it's dead. But you stir it and give it life.
Perfect.
Stirring up the water in the pond, you bring up the pond.
Yes.
Is that what you're doing with a letter to the president?
Exactly.
Okay. Give us now, first of all, the background. You have written a letter to President William Ruto. What about and why?
It is the civic duty of a patriotic citizen to be involved in the affairs of his or her nation. I observe our nation on a daily basis, and I'm worried. I'm worried that we are on the wrong path. And the buck stops with the President of the Republic of Kenya. And that is why I chose to write to him, to raise the critical issues. And remember, in that letter, I remind him that I did write to you on the first day of March. The year 2023, and on that occasion I wrote to both him and Mr. Raila Odinga when the country was in trouble. Of course, I've been vindicated. What I did suggest is what came about. The two gentlemen have entered into a rapprochement, and they are singing all the way to different places. But not for the benefit of the nation.
There you go.
Because things have gone south, in my view, and they continue to go south. And it is our duty to remind the president that you took an oath to serve your country is unhappy. That was the genesis.
Has it been received?
Oh, of course, the letter was received. I have a signed copy. It was delivered at his office in Arambe House, and it was received.
Do you expect a response from him?
I don't. My experience with African heads of state, except 3, they never respond. And I write to quite a number of them. The late John Joseph Pombe Magufuli used to respond to letters. Yoweri Kaguta Museveni responds to letters. Paul Kagame responds to letters, and I must also remember that Chakwera of Malawi does respond to letters. But Kenyan presidents, and I've written to all of them except Jomo Kenyatta, never respond to letters.
So even last year's letter was not responded to?
No, was not responded to.
Okay. In this letter, you tell the president a number of things, of course, reminding him about last year's letter and telling him what you felt then. And then you say it's common knowledge that the political rapprochement rode in the crest of protest by a segment of young Kenyans, Christ and Gen Z, in the month of July, during which they dramatized their dissatisfaction with the finance bill and the performance of your administration in several key areas. In response to their popular demands, you returned the finance bill to the National Assembly with all provisions deleted and dissolved your cabinet, which has now since been reconstituted in partnership with ODM. Your Excellency, your actions notwithstanding, and as I write, the National Intelligence Service will have informed you that there is a circulation of a lamentation about Kenya titled "Cry, My Beloved Country." And you quote that "Cry, My Beloved Country." What circulation is this, PLO?
You know, somebody sent me that particular poem, if you may, crying about the country. And if you read that poem, the individual is listing a number of concerns.
Yeah.
This is our country where governors and others are looting. This is our country where things are not happening in the right way. And you cannot fault all the issues that are raised there. And the gentleman is saying, but even when this is happening, there appears to be no positive response. It is business as usual on the part of the political class. Look, for example, at the finance bill. Without precedent, there has never been in the history of any country that I know where the president, upon receiving a bill, returns it with all provisions deleted without recommendation as to what ought to happen. We are now back again. The finance bill will be back with a bang. Cabinet reconstituted, and the individuals whom we thought would leave cabinet are back there. And in fact, when they are being vetted, they tell us how much they have raised or made in the last 2 years. Personal fortunes have increased, but the fortunes of the country have dwindled. These are concerns, and yet we are not angry as Kenyans. So that what the Gen Z did was to scare the political class for only a short while. And after they have entered into this alliance with the president, has entered into this alliance with Mr. Raila Odinga, he now feels that he has settled the political temperature, because by doing so, he has ethnicized the politics of the country, and in his mind, I think, neutered the movement of the young people. So you can do whatever you want. And this is not without precedent. We have seen it. We have seen it with the President Moi. We have seen it with the President Kibaki after 2008. We have seen it with President Uhuru Kenyatta, and now with President Ruto. If you remember, during the campaign, the president said, I will not allow myself to enter into any engagement with Raila Odinga.
Yeah. Bonapino, I hear you. Bonapino, there's something you've said, and I think it's interesting, that when you look at the unfolding of events, you've said that Kenyans are not angry. Kenyans are not angry, and that's why you don't see what any kind of action. The Gen Z protest did quite a thing in terms of putting a fork in the road in terms of where folks are going to go. But you've gone ahead to say that Kenyans are not angry. What would you see if Kenyans were?
If Kenyans were angry, Kenyans would sustain the protest. The middle class would sustain the protest in an organized manner. And we saw this in Sudan. When the middle class, the doctors, the lawyers, the business people, the engineers came to the street, until Omar al-Bashir left office. We saw this in Bangladesh, until Sheikh Hasina ran away and the entire cabinet ran away. We are not saying that they ran away or leave office. We are simply saying until they respond positively and do the things that are in the interest of the nation. But Kenyans very quickly become ethnic. I saw, for example, when a few individuals were appointed into cabinet from Nyanza. When you are in some of these forums which are ethnic, a number of the individuals from the Luo community are now saying, we now control the treasury. The money is now kept in Homa Bay. We are happy now. And you cannot run a nation on the basis of giving pride of place to primordial ethnic instincts. You soon divide the people. You hold homecoming parties and celebrate, and he who was the devil becomes the angel. And the anger is only as far as your political kingpin has not had his need satisfied. Once your political kingpin has been taken care of, then we all say, hallelujah, it is well with us. And that, I think, is one of the most unfortunate things in the Republic of Kenya. And if you hold a different opinion, like I tend to do, you can become the enemy.
Indeed.
You become the enemy.
But these same Kenyans, the people that you speak of, for whom, again, are sovereign, still have issues that are supposed to be taken care of, which to an extent are not. It's the same Kenyans that you say hold up the tribal position as sacrosanct, but still are suffering very many things. Education in the doldrums, healthcare. I mean, it's obvious what's happening with healthcare today. We have an infrastructure that could do with a good kick in the pants, if you know what I mean. But still, we hold this positioning or this ethnicity or this tribalism at a higher regard than livelihood.
You know, my sister, there's something that we call the Stockholm Syndrome, where he or she who has been captured begins to love the captor. And this is the situation with Kenyans, that the politicians insult, abuse, and humiliate them on a daily basis. But somehow, they are quick to defend them. You've talked about the health sector now. See what is happening. But somebody is going to defend. I listened to the minister for the time being in charge of the health docket. She appears to be completely clueless. But yet, if you wanted to remove her from office today, her tribesmen and women will come and say, that is our daughter. I saw the case of the acting commissioner, IG, who literally disobeyed court orders. And people are saying, but he's from our tribe. And this happens, and I always remind myself this, that when a country is hurtling towards its destruction, then even when God himself reasons with their leaders and the people, they think God mad. They sacrifice at the altar of ethnicity to the detriment of the nation. So they are complicit in all these. But if people are angry and they want the right things done, then they will insist that the things be done. And I want once again to remind all of us of what happened in Bangladesh, which was after the Gen Z protests in Kenya. They were so dissatisfied with the Sheikh Hasina government, and they were disciplined. They went to her palace. She was airlifted to India. The ministers have all run away, and then they appointed somebody to be in a caretaker position because they were angry and they know what they want. Kenyans know what is wrong. But when it comes to tribe, somehow we give it a pride of place. And that is why the country continues to underachieve. That is why we are not running a democracy. We are running a kakistocracy, a government of our very worst. I listened to some of the lady talking about the impeachment of the Kericho governor. And I said, this is our leader, can barely